And it is precisely because of this problem sometimes that families are now a little bit nervous about third-party trustees. They create their own trust vehicle called a private trust company, which the family tries to own itself. The challenge with that is, whilst it gives them a level of control, it sort of undermines the substance thing which Mr. Oswal was talking about. So a tax officer looking at it will say, where is the trust? I mean, you just created a private trust company, you and the trust are the same, and there is really no trust at all. So again, that's an extreme argument, and there are ways of doing it properly.
It depends, as Mr. Shroff said, that yes, protector or enforcer, this is a very common concept internationally for a trust which are set up abroad. You normally, if you have got the trustee companies who are managing your trust, you should create a protector's office, because that can protect your interest, and he will be guided by the instructions given. In the event of there is a conflict of this nature, possibly he can safeguard you.
Yeah, and it lands up in a court.
Correct. And sometimes it is advisable. Now, for example, as Mr. Shroff said, that in situation when you have created an organizations abroad, again the issue arises is who will be controlling that. Then you can use some of the jurisdictions internationally, in the case of an international trust, where there are concepts where there is a firewall between the trustees and the company, which is created underneath the trust. The trust holds the company, but the trustees do not have any role to play in the company. So, company is managed by the family members, the trustees do not have any interference rights. Some of the jurisdictions do permit, like BVI or Cayman Island, Star Trust or a BVI Vista Trust, where it is possible to create this type of a firewall between the trust and the company.
Tariq, something from your experience, would you like to add?
See, primarily I don't see why there should be a dispute between the trustee and the beneficiary, because end of the day the trustee has been identified by the settlor for the benefit of the beneficiary. Yes, there could be a possibility that there are a set of beneficiaries and one of the beneficiaries feels that he or she has not been given justice by the settlor. But then that doesn't become the responsibility or accountability of the trustee to be blamed. If the settlor has defined certain rules, in all possibility the trustee's job is to abide by the wishes of the settlor. And if the settlor has defined in a particular way and the beneficiary is unhappy, there's no reason why he should blame somebody else for it. Two is that if you find the trustee guilty, or if the trustee is not doing the job that he or she is assigned for, there's always an option of changing the trustee by going to the court. But in all possibilities, I don't really see why a dispute should happen. If the trust company or the trustee is working in the guidelines, he is there for the benefit of the beneficiary and no one else.
In the international trusts, possibly another important instrument which comes to very important, which plays an important role, is letter of wishes. As he rightly said, the settlor who creates a trust, normally he gives a letter of wishes which gives a complete detailed instructions which do not form part of the trust deed, but it is given to the trustees. And normally our experience is they follow it very sincerely, because their whole business is, the trusteeship business is dependent upon following the instructions. The moment they stop following the instructions, they are out of the business. The reputational risk is very important. And therefore, this is an unwritten contract, illegal. This is not illegal, unwritten. There is no force in law as far as the enforcement of that document is concerned, but it is sincerely followed by the trustees world over.
Because that's again where we emphasize on identifying the right set of trustees, because it's a long-term relationship that's there. Yes, there is an option of having a family member as a trustee, but again, due to tax reasons, due to other reasons, there is a possibility that that might not work in your favor. At the same time, having a family member as a trustee, he or she may have a relationship or a soft corner for the beneficiaries, maybe more for one than the other. So that's a possibility where more partiality or things can be managed over there, but not when it comes to a corporate trustee, because you're like a horse with blinkers. You're supposed to just abide by what's there in the deed or what's there in the letter of wishes. So then why conflict?
More questions? Oh yes. Okay, we'll come. We'll come to you, sir. We'll come to you.
This is Samir Mehta. Question: with the emergence of the estate planning tax, a lot of uncertainty around that discussion in India, what are the challenges perhaps you see in this, especially with multi-stranded families that are now a lot more globally diversified and displaced, and assets that are globally diversified and displaced? So you have assets locally and globally, and you have beneficiaries that are locally and globally from the estate. Do you see any major challenges in this?
Yeah, in case of the multi-country asset situation and the family members having situated abroad, the main challenge is possibly in succession plan. As far as possible, we recommend that you create separate wills for these assets abroad and the assets in India, so that it becomes a smooth succession there without any difficulties. So therefore, that is one important feature one should adopt possibly. And second thing is, if the succession is well laid out, possibly in the jurisdiction like India, there is no estate duty, there is no issue. If you are in, suppose you are a non-domicile UK, India UK has estate duty double taxation avoidance agreement. The only double taxation avoidance agreement India has on estate duty is only with UK, and the non-domicile of UK can take advantage of that. Indian assets will not be subject to the estate duty in UK. That is one another area. Number of countries have the estate duty law, you have to examine that. That could be another challenge which we should see. And if, as far as possible, the person who is the domicile or the resident of that country, if he does not own those assets, but the other country's residents own the assets or the trusts own the assets, this issue also can be taken care. So from that perspective, this is very important tool to plan your affairs through a trust as well.
Sir.
Yeah, Nimish Unadkat here. I just want to ask you this, do these trusts have a definite time span or they can continue in perpetuity? And
Is there a time span for the trust, or they can perpetuate themselves?
In some countries there is a time span, most of the countries don't have. It can be perpetual.
India has a rule against perpetuity.
okay. It's from the tax perspective or the legal?
No, from the legal, from the
legal
trust
angle.
act perspective.
Under the Indian Trust Act.
And one more thing is how easy it is to change the trust deed or the object of the trust to accommodate change in the composition of the family or
Oh yeah, if it is a discretionary trust, it is where the powers of the trustees are given in the manner, and sometimes it is automatically can be created, and sometimes the specific way it can be created. For example, there is an addition in the family members, or some I have come across where the family is conservatively feel that the daughters in the family should be out from the trust after the marriages of the. Then these are all provided in the trust document properly. And then sub-trusts are also created in some cases. A situation may arise that one brother has only daughters and the other brothers have only sons. How do you do that? It's, the care is taken in drafting the trust document.
I mean, very importantly, it
If
becomes
there is a
is-
provision for amendment, you can always.
Yes.
thank you.
That's very importantly, it becomes is the way the trust deed is drafted. I mean, you need to spend a lot of time and get the right drafts in place. You possibly cannot have everything in the deed, but as much as you can spend time over it, as much as you can rule over it and try to see that whatever maximum information can be captured, whatever possibilities can be captured, and certain powers can be given to the trustees, or depending on the set of trustees you choose, to make certain amendments as you go by.
Now, most of the time when you get a standard document from any jurisdiction, examine, find out whether it fulfills your needs, whether it can accommodate. If it is not, then amend it, and then have a provision in the trust deed to create some situations or future situations like that be taken care.
It has to
But
be
in an
customized to your
extreme
need.
example where there is nothing, no power of amendment, and it's very hardwired, you can go to the beneficiaries and you might have to go to the court.
Okay, before that, we'll take your question. What I wanted to know from a corporate governance point of view, are there certain things that one needs to, with all this talk that's going on about corporate governance, so when you're actually drafting a trust and all that, are there things to be kept in mind, things that are getting currency globally?
So there are two universes over here. One is corporate governance, particularly in listed companies, and that debate is going in a particular direction with the New Companies Act and the SEBI code and others, where there is a much greater emphasis on segregating ownership, promoter interests and minority interests. And then there's a separate issue about family governance and how families, particularly with multiple members, they should govern themselves and the manner in which they relate to the corporate. So avoidance of conflicts of interest. Again, this new thing that has emerged about majority of minority voting, where there are maybe related party agreements or there is a conflict, then the majority of the promoter stays away. So from a public markets perspective, debate is becoming very strongly pro-corporate governance. the promoter interests and potential conflicts are not seen favorably, and they're typically expected to abstain from voting. Equally, I think there is now a conversation that SEBI has in its recent policy pronouncements that are coming up, also focusing on how families govern themselves and the need for a succession plan. So SEBI is also pushing forward in terms of requiring boards and consequently families as well to announce a succession plan. They can't have a situation where an important C suddenly sort of drops dead or is removed and there is a power vacuum in the company as well. So the conversation about family governance and corporate governance are both moving in the same broader direction with more need for professionalization, more structure, whether it's family constitutions or trusts, more formality around it. And I think the era where everything was sort of left vague and unspecified, that is coming to an end.
There was a question. Okay, first.
Yeah, I just wanted to ask if all the beneficiaries in a trust want to come together and they want to wind up the trust, is it possible in the Indian trust?
Yes, but it
Yes.
may, drepending on the drafting, and at most it may also require permission of the court, but it is possible.
It is possible. So in
Yes.
that case, let's say a patriarch sets up the trust, and after a couple of generations, actually the beneficiaries do not want to abide by the guidelines that he has set.
Yes.
So how will the family constitution and the governance structures will hold meaning?
So the answer will be found in the trust deed, less likely to find it in the family constitution, though there may be some overlap. But the beneficiaries can come together and wind up the trust. Usually there's a provision for it as well. And there's also something which is sometimes given to the trustees called the general power of appointment, where the trustees can actually use the power to actually set up another trust. Suppose a particular trust has a design defect in it or there are problems. You can actually settle the corpus into a new trust properly designed. But it's a little unclear as to how it would work in India. We think it works, but what tax implications on it may be there? Will it be seen as a power of, if I'm creating a revocable trust might be the issue.
So,
in a number of countries like the US, the trustee is being held co-responsible together with the beneficiaries for making sure that the assets that are being transferred to the trust have been properly taxed before they come in, and that whatever income accrues in the trust is also properly taxed under the countries where it is being active. Do you think that and I see from the US this has been going to Germany, Mexico, quite a few countries are now introducing similar legislation. Do you think something like that will happen in India as well, where the service providers are being held co-responsible for the Indian U-boat to actually report its taxes in accordance with Indian law?
Do you want to take that question, or from a trustee's point of view, or maybe I can
Yes.
give a...
Absolutely.
So, question of whether the assets that are being accepted in the trust are clean assets or not, I think is the question, whether there's a money laundering issue involved over there. So, my experience is that trustees are being extremely careful now of doing all the diligence, the KYC and checking. I think they also take appropriate indemnity that if there's a problem found that the assets were unclean, that they would have recourse to either to the settler or to maybe to the trust assets itself. Best practices from overseas with cross, whether it's international banks who have trusteeship outfits over here, or who are sort of following international practice. They're having a lot of compliance protocols which have to be followed to accept this. Secondly, from a tax department's perspective, I think the tax department as anywhere is getting increasingly more sort of intrusive. But that being said, if you've done your diligence and you've done your checks, I think that's fine.
But as far as the law is concerned, there is no abide or anything that has been enforced on the trustee that he or she will be accountable if they take in assets which are not there. But very rightly said, the international companies are doing their due diligence.
No, but in any case, money laundering law applies to everybody.
Yeah.
Yeah.
So therefore, one has to do a KYC as far as money laundering is concerned. To what extent you are satisfied, it all depends on you.
Okay, so I think time has now come for succession to get kicked in. I think we just ran out of time. I wanted to thank the audience for being so patient and being so attentive. The evidence was the number of questions, and for the panel being so wonderful and coming up with such illuminating answers and lines of thoughts. Thank you so much.
Thank you.